Hi, welcome ladies and gentlemen to this webinar hosted by Khetan and Company on this very practical and interesting subject of making the most of your appeals before the commissioner appeal. So this conversation will be done by me and my colleague Shaili Gupta. So before we begin, let us do a brief introduction of the speakers. Myself, Sanjay Sangvi, I am Senior Tax Partner of Khetan and Company. I'm a dual qualified chartered accountant and a lawyer. I am based out of Mumbai office. My forte is tax advisory, both domestic and international taxation, and tax and transfer pricing dispute resolution. Shaili?
Hello everyone, my name is Shaili Gupta. I'm a tax partner at Khetan's Delhi office. I have more than 15 years experience in handling tax litigation matters, and I'm both a chartered accountant and a lawyer.
So we begin the discussion. We have structured the presentation in five parts: introduction, the appellate procedure, some very important and finer aspects we believe are crucial for effectively handling your appeal before the commissioner appeal. What is our approach at Khaitan when we advise and help a client to deal with the CIT appeal matters? And very happy to take questions towards the end of the session. Thank you. So let us begin with the introduction. Who is commissioner appeal? Or who are the National Faceless Appeal Center? Commissioner Appeal or National Faceless Appeal Center, one and the same thing. The only difference is Commissioner Appeal, you are present physically before a Commissioner Appeal, and in Faceless, as the name suggests, you don't know who is the Commissioner Appeal, but there is the same, it's the same appellate authority. Only thing is you don't know person's name and the face. So Commissioner Appeal is the first appellate authority under the Income Tax Act 1961. So any adverse assessment order passed by an assessing officer can be challenged before the Commissioner of Income Tax Appeals. That's the fundamental of income tax hierarchy. What are the appealable orders before CIT appeal, in short, or National Faceless Appeal Center, NFAC? First and foremost, an assessment order passed under section 143.3, which is normal scrutiny assessment order, as we all know, or maybe a reopening or reassessment under section 148 of the Income Tax Act. Other is the penalty orders, whether it's for concealment of income or any other sort of penalty. Third is orders passed under section 154, which are basically a rectification order passed by an assessing officer or by an appellate authority. They can also be challenged before the commissioner appeals. Other appealable order will be intimation passed under section 143.1 by the CPC Bangalore, which is basically computer driven processing of your intimation or your return of income, not exactly a scrutiny assessment order, where certain orders adjustments are permitted under the income tax law, very narrow scope. So if somebody is not happy with the intimation passed by CPC under 143 subsection 1, such intimation can also be appealed before the commissioner appeal. Similarly, an order passed under section 201, which is basically a TDS default or alleged withholding tax default, where let's say allegation is that a company was supposed to do withholding from a payment made to a non-resident or to a resident party, and taxes have not been deducted, due taxes have not been deducted. Such orders can also be challenged before the CIT appeal. So these are the few most important or fundamental orders passed under income tax law which are appealable before the CIT appeal. What can be appealed before the commissioner appeal? One can file an appeal both on a question of facts as well as question of law, or both. It need not be only a factual dispute or a legal dispute, it can be a mix of both. As I said in the beginning, the appeals are presently heard in a faceless manner. Most of the appeals, barring few exceptions, like if you are a non-resident or a foreign taxpayer, or your appeals or dispute involves transfer pricing adjudication, or is a case of income tax rates or search and seizure, such exceptional appeals are dealt by the physical commissioner appeal in the normal manner, as we were used to it for a historically long period of time. Barring all appeals are to be filed with a faceless appeal forum, and it will be heard on the faceless appeal forum or mechanism. We will now come to the procedure of appellate proceedings before the CIT appeal. I am requesting Shali to please take us through the appellate procedure, please.
Thank you, Sanjay. So let us begin by understanding the framework of the appellate process before the CIT appeal. Now, this is a very critical stage where the factual narrative is shaped, legal positions are articulated, and the groundwork is set for any future litigation. Now, in our experience, appeals that are thoroughly prepared at this stage have a significantly higher chance of success, be it at a higher forum. So we'll begin with the appeal process, which starts with e-filing form 35, which contains a statement of facts, where we set out the factual background of the case and well-drafted grounds of appeal outlining all legal and factual issues that are to be challenged. In our experience, several appeals falter at this very stage due to oversight of critical jurisdictional defects or computational errors arising from the tax computation sheet. Now, while it is possible to subsequently file an application for admission of additional grounds, such remedial measures are discretionary. So it's important to identify and address all the grievances and defects upfront, and in particular where jurisdictional defects exist, or where there's a notice or order is time barred, there's violation of principles of natural justice. These matters must be more appropriately challenged through a writ petition before the High Court. So such remedies can often lead to faster and more effective resolution. But High Court sparingly admits writ petition once taxpayer opts to file an appeal. So therefore, these drafting of grounds is a very critical exercise which needs to be well thought through process. That appeal must be filed within 30 days of time from receipt of the assessment order. While law does permit delayed filing upon showing sufficient show cause or the reason for such delay, but it is entirely at discretion of the CIT appeal whether or not to condone the delay. And where condemnation is refused, the taxpayer shall have to initiate a separate appeal before the ITET, which would again remand the matter back to the CIT appeal. So all this would just unnecessarily lead to increased cost and time. So we strongly recommend treating the 30-day timeline as sacrosanct. And in the next step, we see the Commissioner Appeals Office issuing a notice of hearing. Now, this presents taxpayers the opportunity to submit detailed arguments on both facts and law, supporting documentation that goes as paper book, as well as in many cases, we also file case law compilation, which makes arguments or understanding of the issues easier for the Commissioner Appeal. Now at this stage, the taxpayer also has option to file application for admission of additional evidence. So where there are certain documents which are relevant, but for some reason could not be furnished during the assessment proceedings. The CIT appeal typically in such cases calls for a remand report from assessing officer, and the taxpayers have to submit a rejoinder in response thereto. So we always advise our clients to submit well-structured but concise yet comprehensive submissions. Make use of headings, charts, ground-wise responses. So this helps, this organized structure helps in bringing effective results. And in some cases, we've handled matters where, we've got full relief purely on basis of a robust written submission. Then the law also provides a right to be heard before the appellate authority before the order is passed. So traditionally, this meant appearing before the CIT appeal in person. And as Sanjay mentioned, now the hearing is under the faceless appeal regime in most cases, and hearing in such cases takes place through video conferencing. We also recommend that as part of your written submission, you make a special prayer for seeking a hearing, as well as opt for hearing functionality on the income tax portal. So this would, help you directly address any queries or answer the questions raised by the Commissioner Appeals, and also help you reinforce key points orally in addition to the written submissions. Then finally, the appellate order is passed, adjudicating each ground of appeal. Now, where in any case a ground is inadvertently left unaddressed, or where there's any apparent factual error that could materially affect the conclusions drawn in the order, the taxpayer has the recourse to file a rectification application before the CIT appeal, besides, of course, challenging it appeal in the appeal before the tribunal. Also, Income Tax Act does not specify a strict timeline for disposal of appeals. In practice, the time taken in disposal varies significantly from case to case based on factors like the tax demand involved in a particular case, complexity of issues, and even internal disposal targets of different commissioner appeals. So with that, Sanjay, I'll hand over to you to take forward the important aspects.
Thanks, Shani. We will now come to some very important aspects of how to effectively deal with appeal before CIT appeal. Between me and Shelly, we have really tried to capture some crucial factors that we believe in our day-to-day practice are something one needs to be mindful of to see that your chances of success before CIT appeal are very, very high. So first and foremost, from what date you count your 30 days period? As Shelly mentioned, appeal needs to be filed within 30 days from the date you receive assessment order or the notice of demand. So in faceless regime, whether it's faceless assessment or faceless appeals, so when the assessment order is passed, which you wish to challenge before CIT appeal, under the faceless assessment program, they need to put a copy of authenticated copy of your assessment order in your e-filing portal account, immediately followed on real-time basis, either by an email to your registered email ID or to your registered mobile number, which puts you on notice, which informs you that income tax department has passed an assessment order. It has been deposited into your designated e-filing portal account, and you need to take a prompt action. So it's 30 days from the date you are notified, either by an email on a registered email ID or a SMS received on your registered mobile number. That's the legal counting. Can one avail? Next point is, many times when you see your assessment order, one evaluates whether this is a fit case to file an appeal before commissioner appeal, or in certain cases whether one should explore filing a writ petition before the jurisdictional high court. So it all depends on facts and background of the case, whether CIT appeal is the appropriate forum to seek remedy of the adverse assessment order, or one should knock on the door of writ court. By and large, the fundamental principle is that if there is an alternate efficient remedy like CIT appeal, then in the normal course, a court will be, read court will not be inclined to interfere and give you some relief. They will ask you to participate in a CIT appeal forum, because that is the statutory mechanism available under the Income Tax Act. But there are few exceptions, and which have been very regularly applied by court. If an assessment order, a subject order, is ex facie illegal, it's, let's say it is without jurisdiction, an assessment order is passed beyond jurisdiction, beyond limitation, then you can file the writ petition seeking quashing of such order, or for any such reason, or let's say principles of natural justice are violated. That is another accepted ground for a writ court to interfere if you are filing a writ petition to challenge such orders passed in violation of natural justice principle, rather than filing a writ petition. Sorry, the commissioner appeal. The logic, underlying logic for entertaining a writ jurisdiction or writ petition as against a filing appeal is this: when you file an appeal, as most of you would know, one needs to deposit 20% of the disputed tax demand pending disposal of your appeal. That's the normal norm, unless one is able to get a stay from the assessing officer or from their higher ups, depending on the facts and merits of the case. So let's say you believe that the concerned assessment order, the order under challenge, is beyond jurisdiction. It seriously violates principle of natural justice, or otherwise it has no legal leg to stand. If you still wish to file an appeal before CIT, then first you have to go through the process of seeking stay of demand, because otherwise you are asked to deposit 20%. So that is the cash outflow you are looking at, unless you are lucky and you are able to get a stay, complete stay or a partial stay, or paying department agreeing to accept less than 20% deposit. But if it's a fit case which you have to determine along with your tax lawyer, that writ proceeding in this case is more appropriate. And if the writ is admitted, then you don't need to deposit obviously 20% of the disputed tax demand, and you may get a quick disposal from the high court. Many times at admission stage itself, if high court finds sufficient merit, they may deal with the writ petition at the admission stage itself. For example, a highly illegal order may be quashed by the high court at the admission stage itself. So that's the relevant of this second point, whether you should consider writ jurisdiction or you should file an appeal before CIT appeal. Under present law, appeals must be filed before CIT appeal on online mechanism. So is PAN number mandatory? Yes, PAN number is mandatory, but it's more of a procedural. So I'm not spending time on that, not taking your time. Then next important aspect is production of additional evidence and admission thereof. Many times you may want to support your stand in a return of income with some underlying legal documents, some contractual documents, SPA, SH, or any other some certificate, SEBI registration certificate, any kind of legal document which support your case. And let's say you were prevented by sufficient cause, so by some genuine reason, bona fide reason, which prevented you from bringing such a legal supportive evidence before the assessing officer at the time of assessment itself. Then you have an ability to make an application to the CIT appeal for admission of additional evidence. So you have to apply under Rule 46A of Income Tax Rules, seeking permission of CIT appeal to bring on records for his adjudication certain additional evidence which you believe are very, very relevant to your cause of appeal. So, and many times commissioner, once they look at your reasons for why you did not, why you did not, or why you could not file such additional evidence at the time of assessment, and if the reasons are justified, then they may permit you to bring on record additional evidence which supports your case. Can CIT adjudicate legal issues? Of course, CIT has a legal authority to deal with, as I said in the beginning, both questions of facts and questions of law. So let's say there is an adverse assessment order, or some additions have been taken place, or some directions have been disallowed. CIT has legal authority to set aside such a assessment order, or to set aside such additions, or to give a direction for something which has been disallowed by the assessing officer in the courts of assessment. So they have full legal authority. To on this slide, to in very important legal aspect, whether CIT appeal has power to grant you stay on disputed tax demands. If you refer to section 220 bracket 6, that's a statutory power which empowers assessing officer to grant you stay on a disputed tax demand when you are filing an appeal. So once you approach the assessing officer under section 220 bracket 6 seeking his stay of demand, and let's say that he for some reason he does not agree with your request and he dismisses your request for stay of demand, then you have an ability to approach CIT appeal before whom you are pending. When you have filed an appeal, you can seek stay from CIT appeal depending on the merits of the case. So if you are able to demonstrate before CIT the prima facie strong case, a legal justification or a factual justification where which indicates prima facie, at least on first blush, first look, that you have a high chance of success in this appeal once it is taken up for adjudication, CIT has legal authority to grant you stay till he is able to dispose of your appeal. He may grant you complete stay, he may grant you partial stay. It is in the discretion of the CIT appeal. The point we are trying to make, CIT appeal has full power to grant you stay depending on the merits of the case. You did not go to the High Court seeking stay unless CIT appeal is dismissing your application for stay. Then whether CIT has power to condone delay in filing the appeal. As Shelly mentioned, we have to file the appeal within 30 days from the date of receipt of your assessment order or notice of demand. For some reason, if one cannot file or could not file the appeal within time, then you have to make an application to the CIT appeal, setting out the reasons for delay and on what basis you are seeking condonation of delay. So the best course of action for you is to draft a proper condonation application, attach it along with your grounds of appeal, meaning Form 35, which is your document for filing an appeal, and file it with the office of CIT appeal, and they will consider whether you are justified in seeking condonation of delay. So that will also be a subject matter of adjudication by the CIT appeal. If on perusal of your application for condonation of delay, the CIT feels that the delay was not intentional or not mala fide, and there were sufficient causes or genuine or bona fide reasons which prevented you from filing the appeal within 30 days, then CIT may condone your delay and proceed with hearing your appeal on merits and passing an appellate order.
Thanks,
Shelly,
Sanjay.
over to
So
you.
yes, thank you. So I'll continue with another important issue of CIT appeals power to entertain fresh claims. So CIT appeal can decide on issues that were not part of original assessment order or fresh claims, what we call, that were not included in the taxpayer's original tax return. Now, this is particularly useful because in real world scenarios where an issue may have come to light only after the assessment is completed, or a tax benefit may have been inadvertently missed, at times we see a position may become viable pursuant to a subsequent judicial ruling, or even emerging industry trends, as we saw in case of DDT. Everyone across industry started raising additional grounds at various levels where matters were pending, including before CITP. So, for any of these reasons, the taxpayers can raise fresh claims. The CIT appeal has the authority to entertain such claims, even though they were not raised before the assessing officer. Now, having said that, there is one area of confusion or question which is normally raised to us, is that particularly because of Supreme Court's ruling in Godse, India, which held that AO cannot entertain fresh claims unless they are made to a revised income tax return. So here it is important to note that that restriction applies only to the assessing officer and it does not limit the powers of appellate authorities like CIT appeal or ITAT. So in fact, multiple courts have held that appellate authorities have wide powers, which are often described as co-terminus with that of the assessing officer. In practice, I would say we've come across situations where claims missed in the original return were accepted at CIT appeal stage, significantly reducing tax liabilities. Now, the other issue of coming to power of enhancement, it is important to understand that CIT appeal is not limited to granting relief. Now, the appellate authority also has the power to enhance the assessment, that is to increase your tax liability than what was determined in the original assessment. Now, what this means in practice is that CIT appeal can go beyond issues arising out of assessment. Now, a question that is frequently raised is whether in enhancing the assessment for any year, can the CIT appeal travel beyond the issues transpiring from the assessment order, or is it to be restricted only to the issues adjudicated by the AO? Now, in this issue, the position laid down by the courts is clear. The appellate authority does not have power to travel beyond the subject matter of assessment, and is the Commissioner of Appeals is not entitled to assess new sources of income. So that the power of enhancement is strictly restricted only to the issues covered under assessment. With respect to the power of remand to the assessing officer, now as a general principle, CIT appeal does not have power to remand cases back to the AO for fresh assessment, which was previously allowed under Section 251. Now, following the 2001 amendment, CIT appeal can no longer refer matters back for reconsideration. However, with effect from October 2024, Section 251 was again amended to reintroduce the power of remand, but restricted specifically for best judgment assessments made under Section 144. Now, this assessment would allow CIT appeal to set aside and remand such cases, best judgment cases, for fresh assessments. The next interesting debate question that's very commonly raised to us is whether we should file appeal before CIT appeal or file objections before DRP. Now, there is no single answer that fits all cases. The answer, I would say, depends on a lot of practical and legal considerations. So I'll just first break down the differences for you. Now, in case of DRP, there is no tax demand that crystallizes at the time of filing objections. So you're filing objections against a draft assessment order where there is no tax demand. Tax demand is computed at the time when final assessment order is passed. And in contrast, when you file appeal before CIT appeal, the order is passed, final order is passed, and there is a tax demand. So therefore, the assessing officer may enforce a tax deposit once you decide to file appeal before the CIT appeal, which, as Sanjay mentioned, is usually 20% of the disputed demand. In DRP proceedings, this requirement of tax deposit is delayed by about 10 months. So this can be one factor for you to decide. Another clear advantage of the DRP route is that it operates under a statutory timeline of 9 months. The DRP panel has to pass the order, issue directions within 9 months from the end of the month in which the draft order is forwarded to the assessee. Against this, CIT appeals, on the other hand, does not have a statutory time limit to dispose of the appeal, and the time taken usually depends on complexity of the case and generally the pendencies before that commissioner. Uh, the third important difference between both authorities is CIT appeal has broad powers under 251. As I just mentioned, it has power of remand in best judgment cases and also a power of annulment, while the common powers before both authority is to confirm, reduce, or enhance the assessment. So DRP in that sense has a limited scope. It cannot annul or remand assessment. So basis this, the question is, how do you decide where do we go, whether before CIT appeal or DRP? Now, I feel the questions that you need to ask yourself is, first, of course, are you eligible to approach DRP in the first place? DRP route is restricted only to foreign companies, non-resident individuals, and cases involving transfer pricing adjustments. So clearly, appeal before CITP is open to all categories of taxpayer. So therefore, a domestic company without a transfer pricing adjustment will not have a choice to go before DRP, will have to mandatorily file an appeal before the CITP. So this can be one factor for your decision. And then in many cases, what we observe is some clients have the objective to get a faster path to ITAT. For example, on covered issues, where they know there are issues where relief would certainly not be, is not expected at the first appellate level. So their DRP becomes invariable choice for many assessees. It just helps them fast track and reach ITAT more expeditiously. Then there are cases where taxpayers may want to set the facts and legal position right. We come across various factual complex matters, and in many cases you would not have time to submit additional evidences in support before the assessing officer. So there, we usually advise clients to file appeal before the CIT appeal, because the CIT appeal can understand, adjudicate your facts, and even in the orders, CIT appeals would tend to give a detailed recording of facts in the appellate order. Also, at times, we've seen that mere inability to immediately deposit that 20% tax demand also becomes a driver to choose DRP route. So, where you want to defer the tax payment, you can opt for DRP instead of CITP. That will help you push payment of demand by about roughly 10-11 months. So these factors have to be discussed with your tax lawyers, and they can help you devise a tailored appeal strategy that is applicable or suitable to your situation.
Shally, let me just add one point here. You made several important points. What we have seen in our experience when you evaluate between CIT appeal and DRP on the point of adjudication, our experience, first-hand experience, says that your chances of fair adjudication or getting due relief under law are better or higher in a CIT appeal forum as compared to DRP. Most of you would have seen 8 or 9 out of 10 orders of DRP. They are simply confirming the adjustments or variations, the adverse variations proposed by the assessing officer. So many times, one more important factor for you while evaluating to make a decision between choosing CIT appeal or DRP is where you stand better chance for a fair adjudication. So we many a times we also put a great deal of time and efforts on that while advising our clients. Please carry on, Shari. Thank you.
Absolutely agree with you, Sanjay. So the next question is whether the CIT appeal is bound by circulars. So insofar as CBDT circulars are concerned, it is, I think, important first to understand their nature and legal standing. Now, these circulars are primarily issued to provide administrative guidance, ensure uniform implementation of law by tax authorities. However, CIT appeal is a quasi-judicial appellate authority. So CIT appeal, to my mind, are not strictly bound by such circulars. So while CBDT circular serves as internal administrative instructions, but they are binding only on the assessing tax authorities of tax officers, and they also do not override the provisions of law or judicial precedents. So if CIT appeal is of the view that a particular circular is not applicable in given factual context, or maybe in a case it conflicts with some legal principles laid down by courts, so the CIT appeal would be well within his power to depart from the position taken in the circular. So, I mean, just to conclude, so circulars may help in interpretation, but the CIT appeals would be open for an independent adjudication. Another question that very often is raised to us is whether, in case of intimation passed under 143(1), should the appeal be filed against 143(1) intimation, especially when the case has already been selected for scrutiny assessment under 143(3). So typically our recommendation is to file an appeal against 143 intimation wherever there is an adverse or a negative adjustment. Even if subsequently you're expecting a scrutiny assessment or assessment is even already initiated, even in such cases. So while it may appear that 143.3 assessment would override or subsume 143 adjustments, but this is a debatable area of law. So we have certain a couple of rulings from the tax tribunal, and if I categorize into two situations, there could be one case where the assessment order starts the tax computation from the return of income. Now, in such cases, tribunal has held that doctrine of merger would apply, and therefore 143 one adjustments are academic, and they adjudicate on 143 three additions. On the other hand, there are rulings where dealing with assessment order where the starting point is income as per 143(1). In those cases, tribunal have held that there is no prejudice caused or grievance arising in the impugned order, and a separate appeal should have been filed against a 143(1) intimation. So to err on side of caution and also to safeguard your rights as a taxpayer, it is prudent to independently challenge 143 intimation by way of a separate appeal. And this also becomes particularly relevant where the taxpayer ultimately intends to pursue the DRP route in respect of the 143.3 order ultimately. Because in our experience, we've seen DRP has consistently taken the view that its jurisdiction is limited only to the variations proposed in the draft assessment order and does not extend to adjustments made under 143(1). So, where adjustments, the stance of DRP is that such adjustments are made by CPC and not by the assessing officer. So, in such cases, the taxpayers may be left remediless. So, even for these reasons, where it is clear that the taxpayer wants to take a DRP route, it is all the more essential that you file a separate appeal under against 143(1) intimation. Also, from a practical standpoint, if you log in the income tax portal, you would see two different demands standing in your PAN. One issued under 143(1) and a separate demand under 143(3). And the demands typically CPC would delete only when you submit a order in support of deletion of such demand. So overall, two separate appeals should be filed against 143(1) intimation and a 143(3) order. So I think this brings us to the end of this section on the important considerations. As we've seen that these aspects need to be approached thoughtfully. There is no one answer for all. We need to keep in mind all the legal nuances, practical impact in mind. So I think with that, I hand over to Sanjay, who will now walk us through the approach we typically follow in CIT appeal matters, drawing from our practical experiences.
Thanks, Shani. We now come to our last session, the strategic approach, the legal approach that we follow when advising or helping our clients in dealing with CIT appeal matters for best possible results. Now, first and foremost, what do we suggest our clients? What do we do for our clients? I think this is the fundamental thing, and I think 90-95% of success chances will rest on this point. Please bring all legal arguments and facts on record. So whatever you wish to argue, whatever you wish to refer to or rely upon, please prepare a proper written submission along with a paper book and file it with the CIT appeal. So you basically file two things: a written submission summarizing your facts, law, legal proposition, arguments, and supporting documents. And second, supplement it with a paper book where you attach the relevant documents, your contractual papers, your share certificate, your SPA, your shareholding agreement, etc., some certificates, income tax certificates, SEBI certificates, RBI filings, whatever is relevant in a given context of a dispute. Please bring those legal documents on record by way of filing a paper book and file a proper, well articulated, detailed, and elaborate written submission. These are your best bets before any commissioner appeal forum. Number two, if the primary dispute of your case before CIT appeal is on factual side, then you please request CIT appeal to call for a remand report from assessing officer. For example, we'll share some live examples here. Recent experience, we were advising a Singapore-based foreign portfolio investor. Now, it was a SEBI registered FPI, but for some reason in their tax assessment, the benefit of concessional tax regime as applicable to a registered FPI was not granted. So the approaches were for helping with the CIT appeal matter. So we requested the CIT appeal that, sir, please call for a remand report from the assessing officer, asking him why he did not give the benefit of FPI status to the client, to the taxpayer, when the FPI certificate issued by SEBI was duly brought and filed before the assessing officer. So please consider insisting on a remand report from the assessing officer when the matter is primarily factual. So when there is a remand report from the assessing, when there is a request for remand report from CIT appeal, the officer is then duty bound to say, for example, I am taking my same example. When there was a remand report call from AO, assessing officer, why you did not give the benefit of FPI when you were given a copy of FPI certificate? Now the officer will have no choice but to say why he did not grant the benefit. And then CIT can do a fair adjudication. So remand report is a very important strategic approach. Number three, file additional evidence in case a vital document was not filed or could not be filed before the assessing officer. I think I already touched upon this point in one of the earlier slides. So again, it's very important that when you are before CIT appeal, your facts, your legal arguments, and your crucial legal evidence documents must be available to CIT appeal so that he can take a holistic view and give a proper and fair adjudication. So that's why the emphasis on bringing additional evidence on record wherever it is needed. Number four, undertake a thorough research of legal position on the point of dispute. So as I said, when you prepare and file legal submission, let's say normally we advise clients and we only draft it. We file such written submission at least 7 or 10 days before the date of hearing, so that it is placed well before time before the commissioner appeal, and the CIT appeal can have a look at those submissions when you appear before him for the hearing. Many times we have seen the time from the time you prepare and file legal submission, your hearing takes place. Let's say it's a part third matter. So between the day one you file written submission, day 10 was your first hearing before CIT appeal. After 10th day, after first hearing took place and the matter is marked as part third to be continued on the next appointed date, there may be further legal development. A jurisdictional high court may have ruled something on that subject. Supreme Court might have ruled something on that subject, or there may be a tribunal judgment on the point which is your exact point before CIT appeal. So therefore, undertaking detailed legal research is very, very important. So if you come to know that post filing your written submission, there are some additional new favorable judgments, please make an additional submission and file before the CIT, attaching copy of those judgments, unless of course your appeal is already disposed of. So if the appeal order is still pending, and primarily if it is a part third matter, you are well within your right to supplement your written submissions with additional relevant favorable case law. And as Shelley mentioned in her initial slide, please request for a personal hearing before the CIT appeal. The way this CIT appeal system or forum functions, first you will receive a notice of hearing, notice calling for written submission. They will say that please file your written submission in support of your appeal by so and so date. When you do so, when you file your written submission, towards end, please make a specific request, a prayer that we wish to be heard in person. It will be an online hearing, video conferencing, but that is sufficient. But please do make a request that we would like to also be heard in person via video conferencing. So why that request for personal hearing? Written submissions will do 80-90% of the case for you. It will do 80-90% work for you. But once you are also having a chance to speak up about your submission, you can make better presentation before the commissioner appeal. You can emphasize your point. You can supplement your written propositions with some better articulation. So that's why the benefit of seeking personal hearing. We have several cases, at least a dozen cases, where personal hearing was very, very helpful and it has turned the table in our favor. For example, you are dealing with a treaty interpretation. So while you will set out everything in black and white, but when you have chance of personal hearing, you can give various examples, real life examples in not so technical terms. So that also facilitates a better reception, better understanding, and better adjudication by the CIT appeal forum. So clearly there is a value proposition in seeking personal hearing in addition to filing comprehensive, neat and clean, tight legal submissions. So these are some of the approaches we have found very, very useful when we argue appeals or present appeals for our client. One more point. Let's say your written submissions are running into 10, 20, 30, 40 pages. It all depends on how complexity of appeals, how many grounds of appeals you have taken. Many times what we do, just one day before the hearing or on the day of hearing, we carry one pager note, just one or two pager, where you summarize bullet point forms key propositions. and head over to CIT appeal. So once he has heard you for half an hour, 1 hour, or gone through your written submission on one single page on the face of it, right now, the way you are able to see our slides on the screen, in something similar, you just make out 8-10 bullet points. That's a global summary and reminder for CIT appeal. Sir, these are my key points for adjudication. These are the key propositions I am relying on in support of my appeal. We have found this one pager or two pager notes, whether it is before CIT or even before Honorable IT, to be very, very helpful. Let us also share some practical experiences on CIT appeals in the last 6 to 12 months. And I've actually jotted down 3 to 4 such instances, and I'm sure Cherry will also supplement. Last week, as recent as last week, we were representing a foreign client in appeal, and there was a delay of almost 5 years. Almost 5 years. So we did complete fact finding with our that client. The client, an Australian client, very, very diligent client, very professional, very thorough work. So income tax department system would have sent some intimation under 143(1). So either it did not reach the client, the assessee, or it went into spam box. So therefore the assessee had no notice that in 2019 this kind of intimation raising some tax demand by not granting benefit of India Australia tax treaty was issued. He had no notice, no idea. In 2024, July, August 2024, exactly a year ago, a reminder went, so-called reminder. This time it went properly on the client's registered email ID. So he had a notice that something has come. Immediately they forwarded it to us for our advice. What is this? They are referring to some 2019 documentation called intimation the 143(1). I have never received this. So please tell me what is to be done. So we immediately came into action. We filed an appeal along with a condonation of delay. It was almost 5 years. And I'm happy to share here that after 2 rounds of hearing, at least in the oral hearing, the commissioner said that Mr. Sangvi, I'm inclined to condone the delay because it is not intentional, it is a bona fide genuine case. So we are awaiting the order in black and white, but we believe that Commissioner Appeal will pass an order condoning the delay and deciding the appeal on merits. So that's one. So it is on condonation of delay. Second, we had a client, UAE-based client. They filed appeal in first quarter of 2019. Appeal was pending for good 4 5 years, and then you had this faceless appeal which came in July 2020. So, and they had to deposit 20% tax. It was a medium enterprise, mid-sized commercial enterprise. So, depositing 20% of significant tax demand creates pressure on their cash flow. It's a commercial issue. So while they had decided the facts of that case to deposit 20% and they file an appeal, the appeal was pending for good 4.5, 5 years. So consistently we kept on writing on the window which government opens the income tax department when you file an appeal on your e-filing portal. We kept on sending a repeated request that please hear my appeal, please hear my appeal. It is pending for a long time. We have also deposited 20%. So fortunately, finally, a notice of hearing was issued by Faceless Appeal Forum. It was argued in the forenoon, and I think if my recollection is correct, by 6:30 p.m. same day, within 6.5 hours, we had an appellate order from Faceless Appeal order, fully allowing the appeal, deleting all the additions. So persistence also pays, is very important. And we had filed detailed written submissions, we had filed additional evidence, and we had a very happy ending. On another case, in the case of an Indian resident client, there was some serious factual dispute. It was a case of a Hindu undivided family, and the point was that HUF, Hindu undivided family, was partitioned by the concerned court long time ago. And following that partition of HUF, the income tax department consistently they were passing assessment orders in the hands of different members of that HUF because of the partition. But for one particular year, they took a different view as if there was no partition. And they made an adverse assessment order in the hands of erstwhile HUF, which no longer existed because of court order which partitioned the HUF. So we filed an appeal and we requested CIT appeal to call for remand report from the assessing officer as to when this HUF was partitioned long time ago, and income tax department in the past consistently followed and respected that partition order. Then why an exception is made in this year? What basis? What is the material available before you as an assessing officer to take a different view and not grant the benefit of partition of HUF? So we insisted that the remand report be called, and if possible request assessing officer to also come in person to explain his side of the case. So again, and after that remand report was called and the assessing officer was requested to appear before the CIT appeal along with us, and CIT heard both the sides and passed a fair assessment or a fair appellate order. So if you recollect in one of the earlier slides, Shelley had mentioned that normally assessing officers they do not come in CIT appeal order to justify their own assessment order. But this in this case, he appeared before the CIT appeal at our request. We requested CIT appeal to request AO to come in person before him and explain his side of the case, what made him to disregard partition order of the court and pass an adverse assessment order. So these are the multiple strategic approaches and legal strategy which you should try and put in use to maximize your chances of getting a due relief from the CIT appeal. Shali, if you wish to add something here, please.
Yes, sure, Sanjay. Sanjay, I think one very common experience I've had with several clients is the actions of taxpayers and their counsels during the assessment proceedings and their approach when they analyze the assessment order and decide to file appeal. Now, just to illustrate, many times it happens that the notice is not issued by the correct officer, or there is a transfer of jurisdiction. 127 may not be served, or an opportunity may not be given, and directly 127 order is passed. So one needs to be very cautious of what are the jurisdictional effects. It could be, even as small as there not being a DSC or a valid DIN. And these aspects need to be contested at the right time and before the right authority. And even if these angles are not disputed during the assessment proceedings, we do have some window to challenge the assessment order in a writ petition. However, section like 292B, which talks about participation by the assessee, and the limitation under 124, which restricts and which gives you a very small window to challenge the order before the High Court in writ petition. So time is the essence. If you lose this window of a strict timeline of 30 days, you end up in a legal battle of 10 to 15 years. Typically, that is the life cycle of a litigation in a particular case in India. So what I'm trying to impress upon everyone is that appropriate handling of assessment, and even if assessment is done in house, at the right time, immediately after the assessment order is passed, you should reach out to your tax lawyers and explore each and every review each and every document and explore the possibility of timely filing a writ petition. That can really save you a lot of litigation time.
Yeah. And as we all know, in today's time, unnecessary litigation is very, very costly in terms of time, money, management time, energy. So it's better that we be very diligent, we act in a proactive manner, take best possible legal advice, and stand a good chance to put an end at the first stage itself. So thank you very much. We come to an end of our this interaction and presentation. It's time for us to take some questions. So we have some 11, 12 questions we can see here. Okay, so let me take the first question, Shelly. Uh,
Okay.
the question here is: we have old appeal stuck at the CIT appeal stage for so many years. We have not seen any movement on that. In some cases, while legal submissions have been filed, no order has been issued or no hearing notice has come. What do we do? How do we expedite? So as we said earlier, if appeal is pending for a long time, please write on your window in your e-filing account to the CIT appeal that my appeal is pending for such a long time. Please issue a notice of hearing and also clarify that we have already filed detailed legal submission on so and so date. So please kindly issue notice of hearing. You can't force them, unfortunately, but keep trying. As I shared one example in case of a foreign client, we wrote 6 to 7 times and they issued the notice of hearing and the appellate order was passed in the same day evening. So that is one approach. Second, for example, I don't know exact facts of this query, but let's say the appeal is pending for 3 or 4 years and there are high stakes involved and perhaps you have deposited 20%. Then consider filing a writ petition with your jurisdictional high court and seek an order from the court directing the appellate forum to dispose of appeal in a time bound manner. We have recently seen Gujarat High Court issuing a direction to Faithless Appeal Forum to decide the appeal within 2 months' time from the date of the order. So that option is available to you. So please consider your facts and make a determination whether you want to make repeated request on the uh, window which is available to you for CIT appeal, or you want to file a writ petition seeking court interference in terms of direction to appellate forum to pass a appeal order in a time bound manner. So that would be our response. Another
I'll
is
take
there
up
is
the
a
next.
delay. Yes, yes, go ahead. Go ahead.
Sorry. So the next question
Yes,
is
sure.
on request for personal hearing, is the CIT appeal bound to give an opportunity? So as I mentioned in during the webinar, of course CIT appeal is obligated under law to provide you an opportunity, but we strongly recommend the clients that one put a specific prayer seeking a personal hearing request in the written submission, and also click on the seek the video conference functionality available on the income tax portal when you submit your written submissions. Despite this request, I mean, typically a video conferencing hearing request is granted in all cases, but despite this, in case opportunity of hearing is still not allowed to you, and there are critical facts which could have changed the outcome of the appeal, you can very well file a writ petition before the High Court, stating that there is violation of principles of natural justice.
Thank you, Shali. Another question, there is a delay in filing of appeal. Should one file the condonation application upfront, or should one wait for CIT appeal to issue a defect notice saying that there is a delay? Our response is you should file the condonation application along with your appeal filing. Please do not wait for CIT office to point out the defect in terms of there being delay in filing the appeal. So please be prompt enough and file your properly drafted detailed condonation application along with the CIT appeal form number 35, grounds of appeal, statement of facts, and your condonation application. In our view, that will be the right approach. Another interesting question, Shali, let me take a shot at this. Are there any broad points guidance from your end to choose among CITP or DRP or REIT before High Court? I think as a part of presentation, we both already touch upon this point, but I'll again summarize. You have to evaluate three, four important points. Merits of your case, cash flow issue. Are you okay to deposit 20% of the demand? Are you okay to wait for, let's say, 2, 3, or 4 years if you choose if you choose CITP forum versus DRP? As Shelly mentioned, DRP will be a time bound disposal, 9 to 10 months from the date of filing the objection. You will have an order of DRP, and whether you should file a REIT petition. So REIT is not really a generally available option when you are dealing for first appeal before CITP or DRP. As I said in the course of our initial comments, a REIT as against CIT appeal will be considered only in exceptional cases that the concerned assessment order or adverse order is totally illegal, no legal stand to stand beyond jurisdiction or principles of natural justice violated. Otherwise, one will have to go through either CIT appeal forum or the DRP forum.
Sanjay, I'll take up the next question. Maybe we can
Yes, please.
jointly address.
Yeah.
So this question, is it feasible to submit legal opinions from lawyers or consultants to defend a position taken in the return? The short answer is yes, it certainly helps, particularly to defend penalty proceedings at a later stage. It will help show your bona fide. And also, these opinions may not necessarily be restricted to tax interpretation issues. Just to give you an example, I was dealing with a case where 80IB 11 exemption was being availed by the taxpayer, that whether 80IB 11 allows deduction for assessees to taxpayers who are into processing, preserving fruits, vegetables. So the debate really there was whether dry fruit is a fruit or not. Now, this is not a tax issue, but we took a legal opinion from the botanical university and authorities and specialists, basically in that area, to demonstrate dry fruit is a fruit. And on that basis, the tax officer gave us relief. That is one experience I would like to share. So opinions need not be really on tax points, still helpful to us. And even on tax interpretational issues, we've seen the assessing officers dropping penalty, or and later at a appellate level, we've seen relief on penalty matters as well. And even in the quantum appeals, it does have a persuasive value.
Thanks, Sir. Another interesting question we have. What if we have not submitted additional evidence in the first submission at CIT appeal due to unavailability of the same? When we can file additional evidence, till date no further notice is received. Shall I file now or wait for other notice? No. It should have been filed at the very first opportunity. In case your matter is still part heard, yet to be decided, you have at least one more chance of hearing. Please immediately today, tomorrow, if not today, please file an application for additional evidence.
So next question, Sanjay, is it mandatory for AODR to make appropriate representation submission to CIT appeal? So we'd already addressed this issue that the department assessing officer does not appear in CIT appeal hearings. In case any additional evidence is filed, the only representation is in terms of a remand report that is received from the assessing officer. No, he does not come for personal hearing.
Yeah, and the logic is that unless there's a barring a remand report request from CIT, an officer doesn't need to justify his order. He has already set out his reasons in the assessment order, right or wrong. He has given the reasoning, and that is what you have to challenge before the CIT appeal.
I think we
We
have
have
one
three
more
more
question.
questions.
You,
Yes,
okay,
please, Shali, please go ahead.
yeah, could you please let me know whether the demand of 20% also needs to be paid on the penalty order, or is it limited only to tax demand provided in the assessment order? So the 20% pre-deposit requirement equally applies to demand arising out of penalty orders. Sanjay, there's
One more
one more
question.
question if you'd like to take up.
Yeah, yeah, 1 second. If we don't prefer to file appeal against the penalty order, wherein the assessee has been mentioned as non-cooperative due to the low sum of such penalty demand, whether it can have adverse impact in subsequent proceedings. It all depends on exact facts. If because of low tax demand you choose, you don't want to litigate, you want to buy peace of mind, and you just concede for that reason, you may not even file the appeal. But then please make sure, even if you don't file an appeal, please file a proper communication, at least with the assessing officer, that this is the penalty levied in my case. I do not agree with this penalty. There was no default. I have not filed an appeal for the simple reason this appeal amount is not significant. I want to put an end to this litigation and buy peace of mind. For that reason alone, we have not filed an appeal. It's not to say that we are accepting the guilt. So please make your point very clear. Bring it on record. There is one more question. What has been your experience with CIT appeal condoning delay in filing of appeals? What key factors should be kept in mind to improve the chances of CIT agreeing to condone the delays? As we shared earlier in the part of our as a part of our presentation, first and foremost, you have to demonstrate before CIT why you could not or did not file appeal in time. What were the reasons? So you have to highlight the bona fide, the key reasons which prevented you from filing an appeal within the timeline. For example, the recent experience we shared, the client never received the original intimation in 2019 2020. So the client had no notice that any such intimation has been passed, making an adverse assessment. And when it came to know about such thing 4 years later, when there was another email to client which it had received, then immediately file an appeal. So it was able to highlight that I never received, this is the evidence that I never received any intimation or adverse order or adverse communication in the first place in 2019 2020. So first key point is, please prepare yourself to see that you are able to demonstrate the bona fide or justification which prevented you from filing the appeal well in time. But higher the delay, difficult the task. We were lucky that in 5 years, for 5 years delay, we were able to get a condonation from CIT appeal. But that's all depends on facts and circumstances and how effectively you are able to present your case before the CIT. You will ultimately convince the commissioner appeal that he will be justified in condoning a delay of 1 year, 2 years, or 5 years, and for these are the reasons.
Sanjay, there's one more question. CIT appeal remanded back to AO to re-verify X expense. AO asked details about X and Y expense. Is it permissible? So, how what I understand the facts is that the during the assessment both X and Y were examined, and now the CIT appeal has remanded back. Now, a clear remand, as I mentioned, is not possible. The CIT appeal cannot not adjudicate and remand it for re-verification completely. However, we've seen cases where they will, in principle, decide the appeal on the issue one way or the other. And possibly in this case, what may have happened is they would have allowed it subject to certain factual verification, which is permissible.
So with this, we come to an end of this session. Thank you very much for your patient hearing and joining us. Thank you very much. In case you have any further query, feel free to email it to us. between me and Shelly, will be happy to respond to you. Thank you very much.
Thank you, everyone.
Thank you. Take care. Bye.
Bye-bye.